That was a verbatim quote from the jurisprudence of this court. The same rationale, in my respectful submission, must continue to the trial process, to the trial stage before Your Honours. Now, Your Honours, my learned friend Mr. Roux, of course, is an experienced lawyer of great repute and makes extremely eloquent submissions always, and it's an honour to be in the same courtroom with him and likewise with Mr. Sir. But of course, once again, we are not in France, and I do not see for the life of me why another French individual, however eminent, like Professor Badinter, should come to this court as an expert, and his views should be accepted, and yet somehow the views of the International Criminal Court should be disregarded. It seems rather perverse, or curious at the very least. Your Honours, the International Criminal Court and the law and jurisprudence emanating from that organ may not be binding directly upon Your Honours, but at the very least it is indicative of the views of a great many number of states. And the particular rule dealing with victim participation did not emanate from a common law system. It emanated from the great country of my learned friends that now seek to oppose victim participation in the manner that I have adumbrated, that I have set out. Your Honour, Cambodia itself, a sovereign and respected country that hosts us here today, is a signatory to that court and has accepted the principles of that court. Now, on a technical level, I fully accept that participation here is that civil parties are civil parties, whereas at the International Criminal Court, they only have party-like rights. But, Your Honours, I would urge you to go beyond the formalities and look at the actual purpose and role of participation. The International Criminal Court, in the case of Prosecutor Anne Katanga, decision on the set of procedural rules attached to the procedural status of victims at the pre-trial stage of the case, 13th of May 2008, at paragraphs 38 and 39, cast what I submit is an illuminating and cogent piece of advice on this issue. Indeed, not only advice, but legal guidance. Your Honours, I will quote paragraph 38. In other words, the ICC said, the interests of the victims go beyond the determination of what happened and the indictment of those responsible, and extend to securing a certain degree of punishment for those who are responsible for perpetrating the crimes for which they suffered harm. At paragraph 39, the judgment continued. These interests, namely the identification, prosecution, and punishment of those who have victimized them by preventing their impunity, are at the roots of the well-established right to justice for victims of serious violations of human rights, which international human rights bodies have differentiated. I repeat, which international human rights bodies have differentiated from victims' rights to reparations. Your Honour, a whole host of jurisprudence was cited by the ICC, from the European Convention of Human Rights, including French cases, to the Inter-American Court of Human Rights. Your Honours, Rule 33 Article 33, that governs Your Honour's jurisdiction, makes it very clear, and it's relevant to this particular submission and also to a submission put forward yesterday by my learned friend, Counsel for Civil Party Number 2. It's far too easy, and it would be a sad loss in my submission, to close one's eyes to the accumulated knowledge of international jurisprudence from other international courts and simply say this court is an island unto itself. That was not the object for this court's creation, and that was not the object to have international involvement in this proceeding. It makes it very clear, Article 33, that if these existing proceedings do not deal with a particular matter, or if there is uncertainty regarding the interpretation or application, or if there is a question regarding the consistency with international standards, guidance may be sought in the procedural rules established at the international level. Your Honour, no law in any system is static. That applies to the civil law, the common law, and international law. I would urge Your Honours, in deciding this matter, to look at the clear thrust of procedures evidenced in a whole multiplicity of jurisdictions and as articulated in the International Criminal Court, and as, in my submission, is clear from the object and purpose of this court's creation and the rules established. There is no clear prohibition that would prevent us calling witnesses, if Your Honours were so minded, to speak on issues. It would then, of course, be for Your Honours to accept it or to disregard it. Your Honours, I cannot leave this subject without addressing my learned friend's, Mr. Roux's submission that to allow the views of victims to be heard would be regression, not progression. That view, with the greatest of respect, is highly presumptuous. There has been no indication from me in my filing or in court that vengeance is being sought. He expressly stated civil parties that vengeance would be sought. Your Honours, international and national experts would be heard, and Your Honours would decide. But I can say for the record that the civil parties that we represent in Civil Party Group Number 1 do not want vengeance. They do not want blood. They want justice, and to be prohibited on an arbitrary manner from calling evidence that may assist Your Honours based upon the municipal practices as interpreted in France is completely, well, I wanted to say something more gentle, but I would say it's completely unmerited, if not absurd. Your Honours, those are my principal submissions in relation to this matter, and I would ask that Your Honours do not simply seek to stifle the voice of the victims. If relevant evidence is relevant, if it will assist Your Honours in deciding the issues of reparation and sentencing, or assessing the harm and trauma suffered from a psychological point of view, I would urge Your Honours to consider it once again with the most anxious scrutiny before summarily dismissing this application. Your Honour, unless I can assist further, and Mr. President, those are my respectful submissions.
Thank you, Mr. Khan. This has been a useful discussion on the topic, but I remind the parties
Madame la Présidente,
that this is a preliminary discussion because the parties have not yet had an opportunity to comment in full on the list provided by Civil Party Group 1, and further comments will be sought, will be permitted in writing. However, the trial chamber felt it was useful to have this discussion concerning the role of civil parties in public. I need to tell Council that we will not perhaps be quite so free with giving time for such submissions in the future. But thank you in any event. Now, Mr. Roux, one final matter, please. You did mention in the course of your submissions that you would envisage asking the Chamber to call an additional expert. Should you wish to take that matter any further, you will of course be aware of the time limits. If you propose this person as an expert, there are certain time limits that must be observed, and we would just want to draw that matter to your attention. I'm not inviting the application, I'm simply drawing it to your attention.
J'entends bien, Madame.
I do take your point, Your Honour. This is aligned with what we said yesterday. From the moment when, as things evolve, we discover in lists of witnesses, we discover new proposals, well, necessarily we will also be coming up with our own requests for experts. Either we make these requests ourselves or we suggest that the Chamber summon such people. I would like to recall that Mr. Badinter would not speak as a Frenchman. He is, after all, an international figure. As a former head of the Constitutional Council of France, he is he is cognizant of civil law systems, and not only in France. So let us not be reductive in terms of what his expertise is. And today, objectively speaking, I think we can consider him to be one of the deepest experts in the world. He was also an active participant in the establishment of the ICC and in developing human rights rules. I don't think you would find a better qualified person around the world to discuss the question that we are now occupied with. Thank you, Your Honour.
Thank you, Monsieur Roux. Mr. President, I believe that concludes this portion of the initial hearing concerning witnesses. Thank you.
Your Honour, Mr. President, there is one very brief matter that concerns 4.1 of the agenda, and I'll be exceptionally brief. It's our respectful submission that some guidance should be given by the trial chamber on two issues. Firstly, the number of civil parties that may wish to speak, and secondly, when their participation is envisaged. I can say that we hope to file shortly, in the next week or maybe two, an application or a motion to the trial chamber stating that out of the perhaps 38 or 39 civil parties that we represent or hope to represent in accordance with Your Honour's order, we will seek to call at most between 7 and 10 to invite them to speak with Your Honour's leave. I would respectfully submit that similar indications perhaps can be sought from other civil parties, because it just may assist all individuals, and particularly Your Honours, in having a view as to the length of this trial and helping in the case management side of judicial functions. The second issue linked to that is the order of witnesses being called. And it's very clear that under the rules, Your Honours, under 91, can hear the parties in the orders that you so determine. It's my submission that there are two principal options. The first is that a decision can be made by party. If that's the case, it's my respectful submission that the prosecution should go first, a civil party witness should go second, then a civil party that may wish to speak, and then finally the defence. The reason I propose this order is that it may be more conducive to Your Honour's exercise of discretion and understanding the case, because the prosecution primarily should set the parameters of the case, and that would allow the civil parties to support them. Your Honours, if Your Honours were minded to divide the evidence by type or nature of evidence, of course that's an option for Your Honours. I would similarly say that all things being equal, that order may lend itself to a more orderly proceeding. So, Your Honour, that's the second matter. The first is perhaps an order to the civil parties, or an invitation to the civil parties that we inform Your Honours as to how many civil parties we envisage we would ask to speak. I'm grateful.
Thank you, Mr. Khan. Is there any other matter before we finish this part of the initial hearing? Ms. Studinsky.
Thank you, Your Honours. I would like to state that the Chamber, Judge Cartwright, granted to the parties 2 or 5 minutes to speak on the issue of rights of civil parties. Then I could observe, after this request to extend a little bit this time limit, Mr. Khan took 19 minutes, if I'm right,
Ms. Studinsky,
to address this matter. And
all counsel exceeded their time limits. I permitted this on this occasion because it's a matter of great interest for the public, and unless there is some other matter that you wish to address, I don't think it's helpful to go even more over time on this matter. Is there some particular matter?
yes, I really would get an advice by the Chamber. I think I was in the deadline of in the time limit of 5 minutes, and I was short, and I, of course, did not exceed in this manner, and I think it is not at all justified by the number of civil parties being represented, but because it is a common issue for all civil parties, and not justified because there are individual particular interests by
Can you tell me
civil
Can
parties.
you tell me what you wish the Chamber to do?
To remind Council, if time limits are set, what is reasonable from my point of view, to remind immediately Council to keep in this time limit, and I'm not speaking about 1 or 2 minutes, but this was exaggerated from my point of view.
Thank you very much. Ms. Jacquin.
Merci, Monsieur le Président. Je souhaiterais que dans les problèmes de procédure...
Ms. Jacquin, Your Honours, as civil party lawyers, I would like to have some further clarification with regard to procedural errors in order to avoid difficulties, particularly with regard to the order in which the civil parties will be taking the floor. Know exactly within which time limit you would like us to take the floor. How far ahead of time you want to know this? There are we represent 30% of the civil parties in Group 2, and we consider that for the schedule, 7 or 8 of our civil parties will take the floor, and I think that some of them have a great deal to say, and some of them may well have been witnesses because some of them are survivors of S21. That is, survivors before the liberation of S21, which means that they were able to escape in sometimes difficult conditions. And I think there will be direct witnesses. And I think that some provision should be made that they be afforded the necessary time to tell their story. Thank you.
Yes, thank you. After a brief deliberation on the bench, the President and the trial chamber would like to remind Council that we seek further information concerning the parties, either civil parties or witnesses, as to the length of time that they might take. We specifically sought that in relation to witnesses, and we would like that indication also concerning civil parties. When it comes time to schedule the witnesses and hearing from the civil parties, we will then have enough information on which to base our determination. So any further information that can be provided would be extremely useful. So thank you. Now, I believe that now concludes this portion of the initial hearing concerning witnesses. Mr. President.
The President. Thank you very much, Judge Cartwright, for leading the discussion on this matter. Next, I would like to give the floor to Judge Yasakon to lead the discussion on the issues relating to additional material filed with the witness list and motion by the co-prosecutors to file new evidence. So, Judge Yasakon, you have the floor. Thank you, Mr. President, says Judge Yasakon. On the 11th of December 2008, in its notification of a trial management meeting, an order to the parties to file additional materials, the Chamber ordered the parties to file inter alia at the same time as their witness list, a list of exhibits and a list of the new documents they intend to offer in the case, containing a brief description of their nature and contents. According to Rule 80, the civil parties and defense have 15 days from notification of the co-prosecutors list to file their own witness lists. The deadline for filing such additional material is the same as the deadline to file witness lists under Rule 80 of the rules. Parties having joined the proceedings after the above-mentioned dates of notification have 15 days from notification of the co-prosecutor's witness list to them to file their lists and additional material. According to the material filed by the parties, none of the parties intend to offer any exhibits, namely tangible objects, as evidence during the trial. The Chamber wishes to acknowledge received from the co-prosecutors, the defense, and civil party groups 1, 2, and 3 of their list of new documents filed together with their witness lists. The Chamber also wishes to acknowledge the receipt of document E510, the motion of the co-prosecutors to submit new evidence pursuant to Internal Rule 39.4, which was first announced at the trial management meeting and filed on the 28th of January 2009. In the motion, the co-prosecutors request the Chamber to allow the filing of film footage of S21 provided by the government of Vietnam to the Documentation Center of Cambodia, or DCCAM. The film footage was not previously included in the list of new documents and the list of evidence that the prosecutors were required to file together with their list of proposed witnesses and experts. The co-prosecutor submit that this material was newly discovered and contains evidence relevant to these proceedings. With respect to this, the list of new documents, the Chamber notes that these documents will be assessed at the same time as the merits. If any party has any objection to new documents offered by other parties or wish to make any comments on the admissibility of these documents, the Chamber will hear these objections or observations today and take them into consideration during the discussion on the merits. The Chamber would like to invite the parties to indicate whether they have any further information or any comments or submissions relating to the various lists of new documents or to the co-prosecutor's motion. Do the co-prosecutors have any comments to make in this regard?
Co-prosecutor Chia Liang, Your Honor, thank you. What Your Honor has described is the submission by the co-prosecutor's office to the trial chamber to accept the new film. I would like to make some clarification as to why there's a delay in the submission of the evidence to the trial chamber after the expiry date of the deadline. The Office of the Co-Prosecutors recently new information 1 week after we submitted the witness list and the additional documents to the trial chamber. We received the news through the international news and through the documentation center of Cambodia that they received this short film from the government of Vietnam. Therefore, the Office of the Co-Prosecutors sent our investigators to examine the short film to see how important it is related to our case file 001. After the examination of the film, we concluded that it is important relevance to the case file 001, and we requested the documentation center to send us the materials to the Office of the Co-Prosecutors. And what was our intention to submit this evidence to the trial chamber? It is important that we see the importance of this new film and that our office has never seen it before, and it shows the view of the S21 office immediately after the liberation, 2 or 3 days after the liberation. It is therefore shown the headless corpse and the chained corpse in Building A within the compound of the office of S21. Second, it shows in the film the victimized children at the office of S21. And this is the evidence that we did not see it before or sent to the trial chamber before. And we do not think it takes a long time to view this film. It's only about 10 minutes long. And one section is only 7 minutes and the other section is only 4 minutes. And it is crucial to show the facts just happened immediately after the liberation. The dead bodies, the witnesses who saw the scene, and also according to Rule 36, as the owner has said, the trial chamber can also delay, can provide extension to the parties to submit additional materials if deemed necessary and important. And also the Rule 92 stated each party has the right to provide additional evidence. I submitted this evidence in writing to the trial chamber, and we are waiting for the decision of the trial chamber. At the same time, we would also like to to enlighten the trial chamber that the Vietnamese soldiers who shoot the film still alive, and the person is now 76 years old, and if the trial chamber thinks it is important for the explanation of the film, it is possible for us to provide the address to the trial chamber to contact the filmmaker. Also, the victimized children, as mentioned by the civil party lawyers, one of the children wished to be the civil party, but due to the expiry date of the application, I would like the trial chamber to consider also that application. Thank you.
Does any civil party lawyer have any comments to make in this regard? Does the defense have any comments to make in this regard? You take the floor. Your Honors, says Mr. Castlewood, regarding the filming footage submitted by the co-prosecutors in the last minute to the court, the defense would like to submit that it is not acceptable. The reason that the defense cannot accept this film footage because these video footages have been provided by Vietnam, the Social Republic of Vietnam, and having used the video footages, I could see that they are politically motivated. So I can see that in these proceedings, we should not have any interference from the political films to be judged by judges here. So I would like to also submit that in the films I observed 8 main points. First, we noticed that the entrance to the S21 from the east, but I could see that in the movie it shows that the entrance was from the west, not from the east, and the location was named S21, and there was no label, no gate, and why they did not preserve the original scenes, and why the primary school of Tuol Slang was taken in the footage, and because people knew that it was S21, but why should in the film people only saw the primary school of Tuol Slang? So that's marks point number 2. Point number 3, I want the court to also investigate this matter, because there was a guard, a location where guard used as the place to guard the prison, but there was not any such place. So I think the movie or the film was not taken during that 1979. It would have been taken long after that. So I think it is rather a political attempt to introduce the film rather than introducing the truth. And in the film there was a basin allegedly used for torturing, but I cannot accept it, because I think these kind of improvised basin would probably be created after 79 for the purpose of that film only. And point number 5, I think the remaining victims people who survived S-21 when Vietnamese troops arrived, I noticed that, now I may put it this way, Duch, you know, when he left S-21, when he went away with 6 people, he left on the 7th of January at 2 p.m. And at that time, all prisoners were executed except 4 people who could not be buried on time at S-21. And regarding this matter, I would like to also submit that the Japanese TV and Australian TV crewmen who interviewed in 2007 in July, they showed 8 combatants who wore military uniforms. Mr. Yasakon, could you please slow down so that the interpreter can follow fully your submission? Mr. Kasawut, actually, the new Japanese TV crewmen and the Italian crewmen who took footage of these people were not really also viewed in the Vietnamese film that filed by the co-prosecutor. So I think there has been inconsistent information that the defense submits that it cannot be accepted. Point number 6. On the 3rd of January 1979, S-21 was ordered by Nguyen Chia to execute all remaining prisoners. So, every prisoner, regardless of a child or children, would have been executed already. So the survivors there were 15 survivors, which were among the Duch group, 6 people in Duch group, and there were other people that I should not reveal their names. We have witness KWO1 as his pseudonym. Took that video footage. Why they did not really take the footage of these people who survived S-21 who at that time? Because they told me that when the Vietnamese troop came to S-21 at the outset, they were there. But why were they not captured in the footage? Why only the children were seen in the film? So we were told that no children left at S-21. They were all executed. So that makes point number 6. Point number 7. All victims, including children and adults, have been starved by S-21, and people were so thin and tired. So I would like also the court to review the video footage to see the appearance of those children. I can see that these children are healthy, and they're not children who have not eaten for a long time. It's not children who have not drank water for a long time. So that's why I submit again, it is not acceptable. That makes point number 7. Point number 8. Before the movie or the footage is submitted, I want to also the court to have it checked against the list of the prisoners at S-21, because everyone who was arrested and entered to S21 is kept at the S21, the complete list. So if these children are the survivors of these S21, their parents' name, and when their parent or they themselves were arrested and sent to S21, their names should have appeared in the list. The reason I want to make sure that the list is well checked, because from the 2nd of January to the 7th of January, there were no people who were being sent to S21 for further imprisonment, because they were all executed long before that. I just want to know how or when exactly these children entered S21, and when we only learn the date of these people or these children entered the S21, that we could know whether they did or they were genuinely the survivors of S21. So if they came to S21 before the 2nd of January, or I may say that they even came to the 1st of January and then hid themselves under the pile of clothes, how could they survive until the day when Vietnamese troops came to take their video film? Because as you already been familiar, there has nothing left for them to eat, and security have been very strict. So when the children did not eat for 7 days and 7 nights, could they survive? They could not. If they could not survive, why can they appear in the film? That's why we, the defense, submits that we really object the submission of such a filming. Also, if we interview these children, because the person who keep the list is still alive, Mr. KW07, who was actually the person who kept the list. And the children were interviewed, and they said that they could not remember their parents because they were too young. So if you think that they were too young, that they can't even remember their parents, how can you call them as witnesses? How can you really presume that their testimony will be genuine or conducive to the truth? That's why the defense submits again that it is not acceptable. From the 2nd of January to 1979, there was no new person entering S21. So I can see that these young children would have lived in this area long before that. And I could also question how they could survive. That's why I have a doubt, and that's, I think it is not really convincing that we should accept the footage. So the defense would like to only request to the trial chamber to remove these documents from being discussed. So if they cannot do that, and that the trial chamber accepts the prosecutor's motion, then the defense would like to inform to the trial chamber that we, the defense, regard these video footage as having political motivation in nature, as Mr. Frankfurt already gave interview in the radio that he regarded this as the video footage which has a connection to political issues. That's why the defense cannot accept it. So we ultimately regard this video footage as the political motivated nature to disguise information or the truth concerning the event. And we reserve our right to raise this issue again in the hearing on the substantive hearing. Thank you. Judge Yasakon, the Chamber will take these comments into consideration and issue a decision in due course. Once again, I repeat, the Chamber will take these comments into consideration and issue a decision in due course. The President, thank you very much, Judge Yasakon. This concludes the initial hearing. I, the President of the Trial Chamber, would like to declare that the initial hearing on case file 001 is adjourned, and I would like to thank the parties and all participants. And the scheduling order for the start of the substantive hearing.
De vous interrompre, mais nous n'avons pas terminé.
I do apologize, Your Honor. As regards the defense, we have not finished our session regarding additional documents or additional material. We still have things to say. We will not take much time, but we do have some things to say as regards documents annexed to the witness lists. Reference was made to the film.
The President, could you please be brief? Because according to, for the purpose of the recording, audio-visual recording, we have only 7 minutes left for the proceedings. So you take the floor.
Thank you, Your Honor. I shall take less than 7 minutes. We wish to supplement on what has just been said regarding the list of complementary documents, 52 documents that the prosecutors have deemed useful to add to their witness list. The defense would like to say quite emphatically that it is shocked after a whole year of investigation by the co-prosecutors, by the co-investigating judges, by the co-prosecutors and by the co-investigating judges, that the Office of Co-Prosecutors should wish to file even more new pieces now. We find this shocking. And I am specifically referring to a great number of confessions, as they are called, from S21 that the co-prosecutor wishes to adduce. What is the purpose? Is this going to make the procedure slower yet? Over a whole year, co-prosecutors have taken part in the investigation and had every opportunity to request such work from the investigating judges. Why should this emerge right at the last minute? And I would specifically like to refer to document 29 in paragraph 13 of the request, a document for which we don't have an original, a document that has already been referred to in the investigation, and that today the co-prosecutors would like to bring back into the pool of documents for our discussion, whereas it has been admitted that the original for this document no longer exists. And the accused denies the existence of such an original. So I wanted to conclude with these comments and remarks, Your Honours, recalling once again that we have rules of procedure and adversarial procedure rules. Right at the last minute, at the very opening of a trial, we are all of a sudden flooded with another 50 documents. We are to see a film, whereas my colleague Savut has just talked about all the counter-arguments here. We are told about an NGO with which the co-prosecutors has worked a lot. I'm referring to DCCAM, that says that there might be a list of 177 survivors of S21, and we should now investigate about this. A new witness is cropping up now, and he is a former child survivor. Now, when is this going to stop? It seems that this will never stop. This very morning, our colleague Mrs. Tudzinski wishes to have additional information on forced weddings. So are we ever going to be able to make this procedure move forward? At the same time, we have the co-prosecutors telling the defense, no, we don't want to have your witnesses testifying because they are not relevant. So I would like to say quite unambiguously, the co-prosecutor's office produces mountains of documents. We have seen that there are 35 witnesses for 40 days of hearings. The civil parties will, and this is quite normal, be heard. And at the same time, the right of the accused to have 30 witnesses heard in 4.5 days, this right should be curtailed? Thank you. That's all I had to say.
The President, the floor is the prosecutor. Mrs. Chia Liang, in order to respond to the defense, I think my colleague will take the floor. Regarding the film footage, we, the co-prosecutors, still submit that we insist that the document be included. The President, could you please break for a moment, because we need the AV and audio recording system to be ready for recording what will be said in these proceedings. Please sit down. Thank you.